Good morning, everybody, and welcome to Kite Solicitors Commercial Property Webinar, October 2025. So our speakers today are myself, Partner Commercial Property, Martin Davis, Consultant in Commercial Property, Emma Nimmo, Senior Associate in Commercial Property, Seb Wallstrom, Associate in Residential Property, and Faye Astin, Solicitor in Commercial Property. And we'll be talking about the Building Safety Act, service charges, best practice, and the new RICS code, upwards only rent reviews, the case of Moth Mansion, and SDLT in light of Angela Raynor's resignation. So I will now hand over to the first speaker, Seb Wallstrom, who will talk about the Building Safety Act 2022. Thank you.
Hello, good morning, everyone. So I'm going to speak to you, as you know, about the Building Safety Act. And as you will appreciate, the Building Safety Act is quite vast, new legislation. I say new, it's obviously 3 years old, but we're still seeing a lot of new releases being put into place or new practices being put in place as a result of it. So today, in the interest of speed and time, I'm going to be speaking to you about two particular aspects, really, of that. So number one, I'm going to be speaking to you about the Building Safety Levy. So before I get into that, I just want to say that it's obviously from the perspective of a developer, and it's assuming that the development, whether it's the Building Safety Act itself, can apply to not just new developments, but the levy itself will apply to new developments. So it's obviously assuming as well that the development is as part of what's called a relevant building, which is established by having at least 11 meters high or 5 stories. Now, apart from obviously all the added red tape that the building control has brought in because of the BSA, as it's referred to. Apart from that, and also the requirement to register it with the government registrar, the building safety regulator, which only applies if it's actually 18 meters or 7 stories. Then, as I say, this levy is a tax on new residential properties and developments, which will be introduced on the 1st of October next year. It will be collected by local authorities as part of the building control process. The income raised from the levy will contribute to fixing building safety defects across England. Developers must pay this levy on certain building control applications before completion of the building works or occupation of the building. So it's whichever is earlier. It depends on the local authority and the levy rates applicable in that particular area. So areas with higher house prices will have proportionately higher levy. The levy rates are set or will be set per square meter of the floor space of that particular development. We're hearing that the rate is likely to be anywhere between £33 per square meter to £100 per square meter. The developments that we're hearing it will be affecting is both complete new builds as well as conversion projects, change of use, and student accommodation. That would also involve mixed-use development in a way that it's only obviously the residential floor space will be used in the calculation for the levy. The levy doesn't apply in retrospect. So as long as you submit your application for building control approval before the 1st of October 2026, then you will not have to pay the levy. There are certain exemptions to the levy, which include affordable housing, NHS hospitals, and care homes, amongst others. So the second part of this I will take you on to now, which is about liability itself, which was introduced about 3 years ago now. I think it was around summer 2022. So how this applies if you are a landlord of a particular flat, or maybe you have a portfolio of flats in what we call a relevant building, that is 11 meters or 5 stories. What you'll need to establish is, on the 14th of February 2022, was the property or the flat owned by a person or a company who owned no more than 3 other properties, or 3 properties in total, shall I say. If it did, then that property is regarded as a non-qualifying lease, which means that certain caps which were forwarded by the legislation would not apply. So we are expecting, and there's a lot of writing around potentially changing the legislation with regards to the date, which is the 14th of February 2022. But currently, that is the date for how you determine whether it's qualifying or non-qualifying. So how you do that is there's a certain documentation which will be provided by the landlord, so we say a lot of the times the freeholder of the building, and you as the owner of the flat would have to provide certain documentation as well to a buyer, or if you're on the other side of it, you would expect to receive it, see and to determine if it is non-qualifying. Now, if it is non-qualifying, that means that there could be potentially unlimited liability towards remediation works for fire risk at the building. So that in itself doesn't make the property unsellable or unmarketable. It just means that there could be trouble or difficulty in finding a buyer, and likewise a lender for that buyer who would actually be willing and able to purchase it because of the liability. To do with that, you would obviously have to make sure or see if the building actually is subject to having remediation work. Since the Grenfell Tower tragedy, what we've seen is a lot of buildings in and around Manchester, they've been remediated, or they are got scaffolding up currently and being remediated. So even if it is qualified or not qualified, if you can see that there have been works done, that doesn't automatically mean that you can't sell the property. So Kuits are one of the limited few firms in Manchester who offer advice on the BSA. So we do act for both sellers and buyers of these type of flats, and we can advise accordingly on the BSA. So I'll take you on now to my colleague Faye, who will speak to you about her topic. Thank you.
Hi everyone. So I'm going to be discussing service charge best practice and the new RICS code. So the new code will become applicable from the 31st of December this year. It replaces the most recent version, which was back in 2018. And it's important to note that whilst the code isn't legally binding and can't actually override lease terms, if the lease is silent on certain points, the code will be inferred, and it's also recommended and best practice to incorporate the code or provisions that are similar to the code into leases. And also, if you are a managing agent that is RICS accredited, then you must comply with the new code. So there's a few different sort of aims with the new service charge code. So I'm going to go through some of the main ones today. The first one is transparency and financial accountability. So a way that this is encouraged is through year-end accounts. So there's now a requirement for year-end accounts to be signed off by someone to confirm that the accounts, supporting notes, and any accompanying records are true and accurate reflection of the actual cost to the landlord of providing the services. So that's something that your property manager will need to do. And the end of year accounts should also follow requirements set by the Institute of Chartered Accountants in England and Wales. And another way to encourage transparency and financial accountability is in terms of the allocation and apportionment of costs. So this must be clearly outlined to tenants, including a written document setting out calculation basis. A guidance recommends a floor area-based apportionment as standard and advises against any other apportionment methods, including using rateable values. And there's also some enhanced disclosure requirements as well. So in the service charge accounts, you need to stipulate all income sources, including any rebates, commissions and incentives. You also need to disclose insurance commission and rebates, any procurement fees, and if during the service charge year you realise it's going to be a material variance to budgets, for example, if there's unexpected expenditure, then you're now required to notify tenants of this promptly and provide an estimate of the potential increase. So another area of focus on the new service charge code is financial protection and controls. So you need to consistently keep your services under review to demonstrate value for money and service quality, which can include obtaining competitive quotes for services where that's practical and cost effective. And you also need to have contract reviews at least every 3 years to ensure pricing and performance remain appropriate. But you're not required to just get the lowest price services, just the best value for money whilst maintaining appropriate service quality. And in terms of management fees, they must be reasonable and a fixed price rather than percentage based. And you can only recover 100% of your proper and actual costs, no more than that. So landlords mustn't permit profit from service charge provision. And any service charge money must be held in a separate bank account, and any interest must be credited to that service charge account. And the new code also sort of increases the previous excluded service charge costs that were in place. So you can't include improvement or enhancement works in your service charge unless you can show that the work offers an ultimate cost benefit value. So effectively saves money in the longer term, although you might get some pushback from tenants on shorter term leases to that. You also can't include initial costs of equipment or fitting out in service charge, future redevelopment costs, or landlord's general management costs, including rent collection and costs of marketing a vacant unit. And in particular, in relation to shopping centres and retail parks, any marketing and promotion costs should be split equally between landlord and tenants, save for initial promotional launch costs, which should be responsibility of the landlord only. And another aim of the new code is to have better communication with tenants. So there's some general principles here. So those involved in service charge administration must act with professional care, diligence, integrity, and objectivity. And the new code sets out clearer expectations on internal team management, including how to handle management charges to ensure that standards are consistent. And you also need to engage tenants as well. So you need to provide opportunities to engage them through regular meetings, provide them with a specific point of contact, and respond promptly to any tenant queries about service charge, and proactively share documentation rather than only upon request. So you might want to consider sharing service charge evidence quarterly or 6 monthly as opposed to yearly. And in terms of providing service charge documents, if requested by a tenant, then you need to provide documentation supporting the costs that have been incurred, including copies of any invoices. And if there is a delay in issuing budgets or accounts, you need to provide as much information as possible on the anticipated level of budget and actual expenditure, and let the tenant know when the documents will ultimately be provided. And there's also some new, quite specific timescales. So you need to provide budgets with explanatory comments at least 1 month before the start of the service charge year. Year-end accounts must be provided within 4 months of service charge year end. And annually, you need to provide a service charge apportionment matrix to show the basis of calculation and total apportionment per schedule for each unit. So another focus of the code is disputes or the reduction of disputes. So the new code tries to increase accountability, so it therefore decreases the likelihood of disputes about fairness and accuracy of service charge, and it could save you a lot of time and money in that respect. It also encourages all new leases to include an alternative dispute resolution clause. So most leases will already have this, but even if they don't, then the code stipulates that the party should still attempt some alternative dispute resolution, such as arbitration or expert determination, before any litigation is pursued. And the new code also sets the standard for best practice. So it may be referred to in court or in any dispute resolution as standard for reasonableness. So you'll be viewed more favourably by a judge or arbitrator if the principles of the code have already been adhered to. And so finally, the code also has got some guidance around environment and sustainability. So any costs associated with this must be properly justified. They might be seen as improvements, which a landlord typically wouldn't be able to include in service charge, or you could try and include them, but you'd need to show that there's a proportionate cost benefit to such work. So for example, it's going to save some money in the long run. The code also encourages environmental cooperation agreements where the landlord and tenants work together to improve environmental performance of a property. And whilst it's just guidance at this stage, it's not actually mandatory, the environment and sustainability points. There's no penalty for non-compliance, but it may be something that is introduced in the future. So it's important to get into good practices now. So in terms of what the new code means for you, you should review any existing leases that you have to ascertain whether the code is referred to, and if so, which version. If the specific version isn't referred to, then it may be that the new code might be implied into any leases. Also ensure that any property managers are aware of the new code changes so they can comply with the code, and review any lease precedents that you have to ensure that any service charge provisions are in line with the code. And these are obviously things that Kuits could help you with if needed. So thank you, everyone. Next up, I'm going to hand over to my colleague Martin, who is going to be discussing upwards only rent reviews. Thanks.
Well, good morning. Thank you, Faye. And today I am going to talk to you about upward-only rent reviews. Upward-only rent reviews have been a distinctive feature and cornerstone of English commercial property leases for decades, offering landlords and investors a crucial guarantee of stable and increasing rental income, regardless of market fluctuations. Pre-1950s, it's probably fair to say that most commercial leases in England had fixed rents for the entire term. Terms were often very long, with rent reviews being rare. In the 1950s and 1960s, inflation and rising property values led landlords to worry about being locked in to outdated rents. During this time, rent review clauses in leases became more popular, although increasingly allowing rents to go up or down to market rent. From the 1970s onwards, high inflation and market volatility made landlords push for clauses that allowed rents to go upwards or stay the same, but certainly not down. And by the late 1970s and early 1980s, upward-only rent reviews were standard in new commercial leases. Therefore, the concept of upward-only rent review clauses being banned is a total surprise and a new concept, because previously, I suppose the position relied on market forces, certainly going back 70-odd years. The current rent review regime typically operates on the basis of review being the higher of the market rent or the passing rent at the time of review. So what's changing? The English Devolution and Community Empowerment Bill was introduced into Parliament 10th of July 1925, and very surprisingly incorporated provisions that would prohibit upward-only rent reviews in commercial leases in England and Wales. Specifically, Clause 71 of the bill proposes amendments to the Landlord and Tenant Act 1954, the cornerstone of English commercial property leases, and which would prohibit upward-only rent reviews for new and renewal leases, but not, it should be stressed, for existing leases. Index-linked rent reviews, which are quite common these days, would still be allowed, but with the provision that the resulting rent could be lower than the passing rent, and it would appear that stepped or fixed rents, where the future rent level is predetermined, would not be affected by this prohibition, on the basis that the future rent is known and determined at the outset. It needs to be stressed that currently the provisions in the bill are at a very early stage, just at the committee stage now, and will be subject to considerable further parliamentary debate. And the expectation currently is that even if the bill is enacted with these rent review provisions, and given the size of the current government majority, that's probably going to happen, but they would not become effective probably until 2027 or 2028. The new law would take effect by the addition to the Landlord and Tenant Act 1954 of a new Schedule 7A, a draft of which can be found in Schedule 31 to the bill, and the ban on upward-only rent reviews would apply irrespective of whether the parties have contracted out of security of tenure rights under the 1954 Act. As I've already said, the provisions would apply only to leases granted after the new law came into effect, but would include any renewal leases granted after that date under the 1954 Act. The key point is that the relevant lease needs to be a business tenancy within the Act, not made under a contract made before the Act comes into force, and containing a rent review clause requiring rent to be determined at a date after the lease was entered into. Of course, for a long time, the property market has worked from an investment point of view because an upward-only rent review gave investors income certainty because rents could never go down, only stay flat or rise, valuation stability for valuers and lenders who could model future cash flows more easily, and a hedge against inflation where high inflation existed. Looking forward, what do we think the effect of these provisions, if enacted, may be on the market? One has to look at the realities, of course, which are that these days, many tenants do not wish to take long leases, and it's not unusual at all to have a 5-year lease with no rent review, and therefore upward-only rent review restrictions are not relevant. One of the prospective provisions in the bill is that where a landlord doesn't seek to implement a rent review because of the danger of rent dropping, nevertheless, and this could be a major change, the tenant will have the ability to institute the rent review, therefore meaning that the landlord would have no certainty or control on rent after a review, where there would potentially be a downward trend in rents. So, for tenants, this is probably good news if the bill is enacted as is proposed, because rents can fall to reflect market conditions, potentially improving business cash flow and supporting small businesses, particularly on the high street. For landlords and investors, however, this is going to lead to increased rental income volatility and uncertainty, and is likely to lead to a revaluation of commercial property assets and may indeed deter institutional and overseas investment seeking stable long-term returns. Landlords may, of course, respond by setting higher initial starting rents, opting for shorter lease terms, or favouring the use of fixed rent increases to regain some income predictability. Clearly, the ban on a collar on rent, i.e. minimum uplifts, is particularly controversial, as it removes that potential hedge against market uncertainty. Well, we'll now really have to wait and see how the debates on the bill progresses, and hope that the fundamental rebasing in the landlord and tenant relationship is not rushed into law without the fullest consideration that it needs. Here at Kuits, we have considerable expertise in providing advice to both landlords and tenants, and will be closely monitoring developments in the area so that these changes, once finalised, can be dealt with in the best way possible. Well, I'm now going to hand you over to Emma Nimmo, who's going to talk about the Moth Mansion case and the importance for sellers to give accurate replies to inquiries. Thank you very much.
Thank you, Martin. Some really interesting points discussed there. So as Martin mentioned, I'm going to discuss the importance of providing accurate replies to pre-contract inquiries when selling property, and also explore the broader implications for sellers who fail to do so. I'm firstly going to discuss with you a case from early this year, which you may have seen in the press, concerning a London mansion house and multi-million-pound misrepresentations made by the seller. The case highlighted the potential repercussions in the event of a seller making what are later found to be false representations when responding to pre-contract inquiries. The case was of Partakashvili and another against Woodward Fisher, also helpfully known as the Moth Mansion case, and the clue is in the name as to what the issue was. The case involved the sale of a £32.5 million luxury property in Notting Hill. Whilst the case involved a residential property, the principles of the case would equally apply to transactions involving commercial property and are important for commercial sellers to be aware of. The case concerned a property which was purchased from the defendant by the claimants in May 2019. Despite not having noticed any evidence of moth infestation during their prior visits to the property prior to completion, the claimants argued that within days of moving in, they began to be troubled by the presence of moths. The defendant and his wife, prior to the sale, had engaged specialists to assist them with the moths in the property. And those specialists had prepared reports and proposed causes of action, one of which the defendants has actually pursued to address and manage the infestation. However, despite this, when responding to 3 key pre-contract inquiries, the seller firstly denied knowledge of any vermin infestation, secondly stated that no relevant reports existed which needed to be disclosed, and lastly claimed that there were no latent defects not apparent on inspection of the property. The claimants argued that those replies were untrue and accordingly amounted to misrepresentations. They also claimed that they were induced to purchase the property as a result of those misrepresentations and had relied on the replies via their solicitors to proceed with the purchase. The claimants sought rescission of the contract and repayment of the full purchase price, plus interest and damages for losses caused by those misrepresentations. So what is rescission? Rescission is a legal remedy that allows a contract to be undone, effectively treating it as if it never existed. And the primary goal of rescission is to restore all parties to the positions they were in before the contract was entered into. Common grounds for rescission include fraud, undue influence, and misrepresentation. The High Court found in favour of the buyers and found that they were entitled to rescission of the contract. They held that the replies given by the seller were objectively false and amounted to fraudulent misrepresentation. The seller knew or suspected the replies were untrue and was reckless in making them. The buyers had relied on the replies, even though they'd not actually read them personally. Reliance through their agents, so in this case via their lawyers, was sufficient. And the infestation of the moths constituted a latent defect, and moths could be classed as vermin. So the seller's failure to disclose the pest control reports and the infestation ultimately led to a multi-million-pound judgment. The court granted rescission of the contract. Substantial damages were also rewarded to reimburse the claimants for losses arising out of their purchase. So legal fees, stamp duty, land tax, and damages for consequential losses. So let's now turn to the broader implications for sellers. There is an established principle of law known as caveat emptor. This is a Latin term which means buyer beware. This is a foundational principle of English law, which places responsibility on buyers to investigate and assess the quality and suitability of goods or property prior to purchase. And the principle has long served to protect sellers from liability for defects not disclosed at the time of purchase. However, in its application to property law, whilst buyers are expected to conduct thorough due diligence prior to exchanging contracts, there are limits to it, and these limits involve misrepresentation. So it does not excuse a seller from providing false or misleading replies. So there remains no duty of disclosure on a seller, except to the extent that failure to disclose would make information which was otherwise given to a buyer misleading or incomplete. So courts expect sellers to disclose material facts proactively, but buyers must still, of course, exercise due diligence. What's important for sellers to remember is that replies are continuing representations. So replies to enquiries are not once and done. They're treated as continuing, as I mentioned, up to the point of exchange. If a seller becomes aware that a previous reply is no longer accurate, they must update it or correct it. So the judgment in the Moth Mansion case stands as a reminder to all sellers involved in property transactions that honesty, precision in responding to pre-contract inquiries are best practice and legal imperatives. Sellers and their advisors must treat the same with care, due diligence, just as you would do with a representation or warranty in an actual contract. So some final points and guidance for sellers when dealing with pre-contract inquiries. So if you're in any doubt, disclose it. If you're unsure, investigate the matter thoroughly. And if something changes, update your buyer. So thanks for that. Hope that was really interesting and useful. I'm going to pass you on to my colleague Adam, who's going to discuss SDLT in light of Angela Raynor's resignation.
Yeah, thanks very much, Emma. Some interesting points there. I'm aware of the case that Emma was talking about, and I can confirm that the damages involved were absolutely eye-watering. So it really was a case to bear in mind in terms of disclosure of facts when you are disposing of property. So thanks to everybody for the previous talks as well. I'm going to close our webinar today with something of a lighter talk, less technical perhaps than some of the previous, and probably quite topical. So I'm going to talk about the case of Angela Raynor, but more generally about stamp duty land tax and its complex nature. I would stress that this talk isn't political in any way. I'm not disclosing any biases or allegiances or any personal points in respect of Angela Raynor or anybody else. It's just a topical point giving rise to some comments in regard to stamp duty land tax. What I would say is that it may be ironic that a politician in this case has had to fall on her metaphorical sword due to what is arguably a somewhat politically motivated tax, or tax with politically motivated aspects, which I'll come to shortly. So a brief history lesson first, very brief, I should say. If you've ever wondered why we refer to this tax, which is more properly called stamp duty land tax these days, but people still refer to as stamp duty, why it's referred to as such, for those not old enough to remember the previous regimes, it's because, as per the slide there, physical stamps were embossed on documents, on conveyances, deeds, etc., to show that the appropriate tax had been paid. It was a tax on documents. It was not a tax on transactions. It ran for hundreds of years. It was one of the oldest forms of taxation that hadn't really changed until the point at which it did. Now, it was clearly archaic, the idea that in order to evidence having made a tax payment, you had to physically send away a deed to an office which would emboss old-fashioned stamps on it. But On the other hand, you could argue that if it had continued in a similar vein for so long, a number of centuries, as the Americans say, if it ain't broke, don't fix it. But fix it, the government chose to do. So in December of 2003, we entered a brave new world. Query whether that brave new world was a utopia or a dystopia, but stamp duty was done away with, or what was also called ad valorem tax, so basically the old-fashioned stamp duty, and in its place, stamp duty land tax, which was a tax on transactions and not a tax on documents. Interesting perhaps to look at some of the comments that were made at the time. I remember it well. I was a more junior solicitor at the time, and I was actually asked at the firm I was working at to look into this in some detail. So I remember it well, and ever since then, for better or for worse, it's been a subject that's been something that I've dealt with at Kuits in particular. So at the time, the Treasury Secretary made comments such that the old system needed modernising and streamlining. Well, I'd agree that it was modernised. We did away with old-fashioned stamps and so on, but streamlined, well, as you'll see, hardly. She also commented that at the time, 2003, only half of the stamp duty owed on large commercial property transactions was being paid. Well, again, without being political, I would absolutely dispute that. I don't know what evidence that was formed upon, but clearly they had to give some commercial justification for changing the system. And finally, the other comment that was made at the time, businesses will notice little change in complying with stamp duty land tax versus the old regime. Well, that absolutely wasn't true. So in came these land transaction returns that you can see on the screen, that those of you who are familiar with purchasing and leasing properties will be familiar with. Lengthy forms which originally were in paper format and had to be posted off in the same way that the old deeds had to be stamped. So yeah, not so much of a streamlining really in that regard. Now, what then were the other reasons perhaps for bringing in the stamp duty land tax regime? Well, you know, whatever your political stripe, taxes are only ever really changed to at least maintain the tax revenue streams, or arguably extract more tax revenue. And in particular with regard to stamp duty land tax, the government and HMRC, successive governments in fairness, appear to have been obsessed, to be honest, with the idea of loopholes and people not paying what they're due and so on. And it's become a sort of cornerstone of the way that stamp duty land tax has been treated. And rather than just relying on one act, the 2003 Act, which brought it in, successive acts have added layer upon layer of complexity to stamp duty land tax, so that I would say that now it's one of the most complex and misunderstood taxes that we have to deal with, certainly in the property world. And an unintended consequence, I suppose, is even some standard property transactions can risk miscalculation and misclassification without taking expert advice, and really entering anything other than a very straightforward transaction without expert advice can be highly risky. So where does this leave Ms. Raynor? So enter Ms. Raynor. The picture you've got there is Ashton-under-Lyne in Greater Manchester, and you'll see why that's relevant shortly. So 22 full years after implementation and following, or arguably because of, multiple revisions to stamp duty land tax, the position is sufficiently unclear that even a very senior politician in the presiding government has been hit by a high-profile scandal. So Ms. Raynor, her family arrangements were, by her own admission, complex, but there's absolutely no suggestion of anything improper or untoward there. So the very relevant point here is that her former family home in Ashton-under-Lyne, I can't say whether it's any one of those properties shown in that photograph there, but anyway, in respect of her former family home, a portion of the property was held in trust for her disabled son, who was at the relevant time a minor, and therefore effectively a trust was set up. And importantly, Ms. Raynor had no beneficial interest in that trust for her disabled son. So she transferred that share of the Ashton property into trust. And what happened next? Well, Ms. Raynor purchased an apartment in the seaside town of Hove, also shown on this slide. Again, I can't say whether it's any one of those illustrated there, but importantly, she paid what she believed in good faith to be the correct SDLT on the purchase of that apartment. No suggestion of trickery or fraud. However, due to a catch in the SDLT law, Ms. Raynor's son, his interest in the Ashton property was deemed for SDLT purposes to be her own because he was under 18 years old. So in other words, the interest which she put into trust boomeranged back to her for the purposes of SDLT, and she was deemed to have retained an interest in the former family home. And therefore, in effect, the Hove apartment was deemed, so to speak, to be a second home. And that meant that Ms. Raynor was liable for a higher rate of SDLT, typically 3 percentage points above the standard rate, and applying to the whole of the purchase price of the Hove property. Again, quickly important to note, no political biases here. Ms. Raynor voluntarily reported herself to the ethics panel of Parliament and reportedly paid out all unpaid taxes, interest, etc. So no suggestion of anything willfully wrong here. But it cost her the post of the second most important politician in Britain, perhaps the third after the Chancellor of the Exchequer. So a massive consequence to her. So what could she have done? Well, tragically, it's reported that she was advised by her solicitors, so she obviously instructed a conveyancing solicitor, not a specialist, to deal with the Hove purchase, and she was advised by them to take specialist advice on the likely SDLT impact of the transaction, but she chose not to. Simple is not always simple, but complex in the hands of an expert can be made more simple. So, in other words, any specialist tax lawyer or accountant should have quickly spotted the anomaly, so to speak, in the rules regarding trusts and minors and would have advised Ms. Raynor, and that would have avoided not only the tax issues for her, but may have kept her job, which was clearly the larger issue for her. So SDLT is a self-reporting tax, so no taxpayer is obliged to follow any advice, but it would have been there. So it's very complex unless you know, in which case it's less complex. So no great sort of takeaways in terms of technicalities or complexity, but very important points here. Stop and think, take the best advice possible. And in terms of Kuits, we have a wide team of experts who can advise you. Now, we don't always know, we don't hold ourselves out in property to be tax experts and to always be able to give detailed advice on stamp duty, land tax or other taxation, but we will always, where appropriate, refer you to specialist assistance regarding these sorts of matters and for all technical aspects where we feel you would benefit and we may not be absolute experts in those points. So working together, we think we could avoid these sort of issues for our clients. I think I've got time for a very quick coda to this, which is hot off the press, really, or relatively hot off the press. It was just interesting to note that the Conservative government, as I say, no political biases here, at its recent party conference, made a pledge that quotes, the next Conservative government, query whether that will come to pass, but anyway, will abolish stamp duty entirely on primary residences. So a couple of things there. They're still calling it stamp duty, despite the fact for 22 years it's been stamp duty land tax, but layman's speak, I dare say. And it's interesting to note that in 2024, so 2024, last financial year, the stamp duty land tax revenues on residential transactions were reported to be £8.5 billion. So where that gap would be filled if that was done is interesting. Well, it's also interesting to note perhaps that those receipts, as reported, fell 27% from 2023 to 2024, from 11.7 billion to 8.5 billion. So perhaps there's something being sensed there that taxes are dropping in this area and that they can be made up elsewhere. But I just thought that was an interesting coda, which is relatively hot off the press. So in conclusion, I hope you found that interesting. I appreciate it was a more general property talk on my part, but I'd like to thank my fellow colleagues for their presentations also, and hope that you've taken something from it all that is of interest and that you can take forward in your own businesses. So until the next time, thank you all, and see you soon.